Have you ever had a neighbor who treats the invisible line between your yards like it's a polite suggestion, not a legal boundary, and then hands herself a badge? Now make that neighbor the HOA president, armed with a clipboard and the kind of confidence you only get from never being told no. I bought this place for the trees, the quiet, that half acre of woods where I could build a workshop, plant, a big garden, breathe, you know what I mean? And within a month, I learned a tiny lesson, the loud way. A petty tyrant with a rule book can be louder than a rock band next door. And if you let her, she'll try to fine you, shame you, and steal your land with a smile. My name's Alex. I'm a professional cartographer and a licensed land surveyor, which is a fancy way of saying my day job is drawing lines that are true, not close enough, true but centimeter accurate, legally defensible, true. And the day Carol marched across the common area with her hurricane-proof hair and her scepter/clipboard, she pointed at my fence and announced I was encroaching on HOA land by 15 feet. 15. I told her calmly, because I'm not allergic to being reasonable, that I'd had a full boundary survey done before closing recorded with the county using GNSS equipment that could find a bottle cap in a cornfield. She tapped a faded hand-drawn plat from 1978 and said this was the official map. And if I didn't move the fence in 30 days, the fines would start rolling like thunder. Yeah, that happened. First notice arrives a week later. Crisp logo. Heavy paper, $50 a day. Retroactive, the kind of letter designed to make you swallow hard. It would have worked on somebody else. But I make my living online, so I stopped being the friendly new neighbor and went to work. I pulled every deed ever recorded on my parcel, every version of the subdivision plat, back to the farm. It was carved from scanned, photographed, geo-referenced, layered the old paper ghosts onto my modern survey, like tracing bones in an X-ray. And something crooked started to glow. Not just my fence line, everything. Let me back up a sec. The original plat from 1978 wasn't just sloppy, it was wrong. The surveyor who laid out the neighborhood miscalculated the basis of bearing from the main monument. That little math sin rotated the entire 200 acres about 3.5 degrees. 3.5 doesn't sound like much until you stretch it across a few hundred feet and watch property lines drift like aimless shopping carts, a foot here, 6 inches there, 15 feet at the far corner where my lot lives. My survey was right. The old map she worshipped was bent. That alone could have ended it. But anyone who bullies that hard usually has a private exception, carved out for herself. So early Sunday before sunrise, I set up my receiver, shot the common area, then the lots around me, including Carol staying on public control points, putting reflectors where I had a right to building a clean, honest picture of our little world. And there it was, the twist that turned this from defense to offense. Carol's fence patio and rose garden, the pride of her backyard kingdom, were perfectly aligned with the flawed plat and 10 feet over the true line, squarely on the land of her quiet, elderly neighbor, Mr. Henderson. I kept digging and found the smoking gun footnote. Almost no one reads a recorded boundary line agreement from 20 years ago between the previous owners of their 2 lots. It acknowledged the plat error and fixed the boundary where the true coordinates put it. Legally binding. Sitting in the title history Carol should have reviewed when she bought her home. She wasn't mistaken. She was banking on everyone else being too scared or too tired to check. So I called David Chin, real estate attorney with a reputation for smiling while he sharpens a legal scalpel. I laid it all out. He paused, then laughed in that I can't believe our luck way only lawyers do when the facts are a steamroller. Bring everything he said. We're going to have some fun. Then I walked to Mr. Henderson's place. Gentle man, widower hands, always smelling like tomatoes and soil, and explained what I'd found. He went pale, then steady. He remembered the documents the day the patio started, the way Carol told him he was a confused old man and threatened him with a dozen violations if he spoke up. He brought out a dusty folder. There it was, the original signed boundary agreement. He looked at me like he'd been waiting years for someone to say, "You're not crazy." He said he'd testify. We set the table for a full-course meal. David filed an action to quiet title and for declaratory relief, not just my fence, but the whole subdivision, asking the court to declare the ancient plat legally defective and adopt my comprehensive survey as the official map. That meant notice to every homeowner and a mandatory appearance on the HOA's radar. And the timing. Well, the annual members' meeting was 6 weeks away, the one night Carol couldn't hide behind emails and friendly edits. If she wanted a stage, I was going to give her lighting, sound, and a screen 20 feet wide. Meanwhile, Carol mistook my silence for surrender and got louder. More fines, bigger threats. A letter from the HOA's attorney so generic I could have found its template under bluster on the internet. The best gift she gave me, though, was physical one. Saturday, she brought in landscapers and had them stake her real property line 3 feet inside my fence while she supervised from the common area like a field marshal. I filmed it clear as day, time-stamped cheerful trespass captured in HD. She paraded past for weeks, pointing at those stakes like they were pilgrim flags. I let her have the victory tour. The trap was already set. The clubhouse meeting was standing room only, humid, loud, and perfumed with community politics. I came in with David and a projector. Carol sat at the long table, board members flanking her like nervous ushers. She sailed through pool chemicals and petunias, eyes flicking to me with that superior little smile. Then came pending litigation. She lowered her voice into fake, solemn church mode and told the room a new resident me had filed a frivolous lawsuit because I wanted to steal community land. Our official map was being challenged by my personal map, but their lawyers were confident, and we all needed to brace for legal costs because of one selfish man. I stood, heart steady, voice calm. "Madam President, under the state civil code, members get 3 minutes to speak to agenda items." David stood too, quoted the exact section, and the room went pin-drop quiet. Carol had to say yes or look like a dictator. 3 minutes, she snapped. "I won't need that long," I said, and powered up the projector. Slide 1. My stamped, recorded survey, clean black lines, coordinates tight as drumheads. Slide 2, the 1978 plat, grainy dotted red like a bad memory. Slide 3, overlay. You could see the 3.5-degree twist with your eyes. Streets and lots skewed my fence well inside the true boundary, while the old map shoved my line 15 feet into the common. Murmurs turned to gasps. "This isn't about a fence," I said. "It's about a foundation that's crooked." Then the fourth slide, the one I'd waited for, zoomed across the subdivision to Lot 24 Carol's. The true line black cut right through her patio, the shaded encroachment box, roughly 450 square feet, sat like a spotlight on the wrong yard. You could hear the air leave the room. Carol tried to speak, mouth open, nothing useful coming out. David placed neatly bound copies of the boundary line agreement in front of each board member, not in front of Carol, and said, gentle as a funeral, "This was recorded in 2003. It acknowledges the error and fixes the line. It was in the title when our president bought her house." In the back, Mr. Henderson stood, voice shaking just enough to remind everyone he was human. She knew he said I showed her. She threatened me if I mentioned it again. The room boiled. Someone stood on a chair and moved for a vote of no confidence. Hands shot up like a field of wheat in a storm. 2/3 wasn't close. It was a landslide. Carol lost the gavel in the room she ruled yesterday. She left without looking back, husband trailing the door, thudding behind them like a final period. After that, the law moved quickly. The HOA's lawyer took one look at the filings, one more at the video of the stakes and the stack of deeds, and advised immediate settlement. The court entered a stipulated judgment my survey adopted as the official map. The old plat void, my fence affirmed the HOA paying my fees from reserves. There were grumbles about the money until people realized the bill was the price of years of bluff and bluster. Not my truth laid bare in 6 slides. And then Henderson, the man who'd been told to be quiet, filed his own suit. The court ordered Carol to remove the patio and the rose garden at her expense and restore his land. I didn't watch the demolition, but neighbors sent pictures, flagstones stacked like little gray apologies on the curb, roses uprooted in neat coils of thorn. Poetic maybe. Necessary, absolutely. What changed after was quieter, but bigger. The new interim board sent me and Mr. Henderson a formal apology, then hired an engineering firm to file the corrected survey for every lot. People started talking again, not whispering about violations or who'd left a can by the curb. Real normal neighbor talk about kids and weather and where to get a good mower blade. The wooden stakes vanished from my yard one morning. Nobody claimed the favor. I built the workshop, planted the garden, learned the exact rhythm of wind in my trees. Peace. The whole reason I moved here finally lived on my side of the line. I didn't want to fight. I'm a quiet numbers guy happiest when the map matches the ground, when a line is a line and everyone respects it. But the thing about bullies is they thrive in the dark. And the thing about data is it's daylight. You don't beat arrogance by shouting louder. You beat it by turning on the lights one documented truth at a time, by using whatever you're good at as a lever until the house of cards tips. Arrogance looks sturdy until you tap it with competence, and it shatters. And when it does, it's amazing how fast a community remembers who it is without the noise. So tell me, does the official rule matter if it's built on a broken foundation, or does justice mean fixing the foundation first and taking the heat for the mess that truth makes? Drop your take on right and wrong here. Where should the line be between community rules and individual rights? And how would you have handled Carol the map in the meeting? If you've lived through a power-drunk HOA or turned your day job into a quiet weapon like I did, share it. The comment section's open, and I'm listening.